Catholic Take, a bold synthesis of information and inspiration. I'm Michael Hichborn, filling in for Joe McLean, who is on a very, very well-deserved vacation. I apologize for the technical issues we had at the beginning of the program, but we're here now, and we've got a friend, Brent Haynes, good longtime friend of the show. He's here with us. We're going to talk about various things going on in politics, and he's a good Catholic attorney. Brent, welcome back to the program.
Hello, Michael. Hello, everyone.
Good to have you back on, Brent. Go right ahead.
Yeah. Michael, did you see the decision by the Montana Supreme Court recently about teenagers getting abortions?
I heard something about this. Why don't you tell us what's going on?
Well, back in 2013, the Montana legislature passed a law, and the governor signed the law, requiring parents to provide their consent for underage girls to get abortions. Now, you would think that, of course, this is a common sense law. Many states have these laws. They are constitutional under the United States Supreme Court. And the litigation, of course, ensued immediately. So even though the law was passed in 2013, it was in the courts for years. No doubt it was slowed down by COVID. It finally reached the Montana Supreme Court. The Montana attorneys defending the parental consent law argued, many of the arguments you would expect them to make, that minors need to have parental involvement when they make life-altering decisions, that minors generally or often lack, the ability to make, critically reasoned, well-reasoned decisions the same way adults do. They argued about the psychological well-being of minors, their medical safety. They argued that parents need to be involved in case there are complications afterwards. Critically, for legal purposes, the attorney's office at the Solicitor General's office in Montana defending the law argued that there was also what is called a judicial bypass provision. Unfortunately, also the U.S. Supreme Court said that it's lawful, it's constitutional under the U.S. Constitution for a government to require the minors seeking abortions to have the consent of their parents. There is this, virtual phobia out there that girls who get abortions or want abortions, or more specifically, girls who have gotten into a situation where, they're contemplating an abortion, they will be subject to horrible abuse at home. So the U.S. Supreme Court requires what is called a judicial bypass, which means that teenage girls can get secret abortions without their parents' knowledge as long as they go to a judge and get a court order to do that. And the parents are never notified about those court orders. That's called judicial bypass, and there are, pro-choice, pro-abortion lobbyists and advocates and attorneys in every state where these laws exist that help girls get those bypasses. I know I've been involved in that kind of litigation myself. Well, all this goes up to the Montana Supreme Court, despite the judicial bypass safeguard being in there, despite, what many of us would think is the absurdity of someone who was 14 or 15 or 16 or 17 years old making a life-altering decision like that without their parents being involved. The Montana Supreme Court struck down the law and ruled that teenage girls have a right to privacy when it comes to procreation, and parents do not have to be involved in that decision, and that the minors do not have to have the consent of their parents to get the abortions. So, bad news for parents in Montana.
Well, yeah, and as a parent myself, I've got 8 kids, and if I was a parent in Montana, I think my reaction would be that it would be one of outrage. I think that parents in Montana would be outraged to hear that the Supreme Court of Montana is going to tell them that, hey, parents, you don't actually have any rights when it comes to your children undergoing traumatic surgery. And let's be clear about this. People die from abortion procedures, whether it's the abortion pill or whether it's actual surgical procedures. People die from this, and you hear about the deaths or the maimings that take place. And if I were a parent, I would absolutely want to know if my child was in danger like this.
Well, and you as a parent, no doubt, many times have had to provide consent for your children to obtain medical procedures. Is that true?
Absolutely.
The schools, won't even give a child an aspirin unless they have consent from the parents. But
right.
Somehow a child can go get an abortion all on their own. So children are not mature enough, according to the judgment of the people in their various forms of government throughout the states and at the federal level. Children are not mature enough to vote until they are at least 18. They're not mature enough to drive, and even then, often with limitations, until they are typically 16, again, with limitations. They're not allowed to purchase and own firearms under the age of 18, and yet they're allowed to go out and get an abortion. This decision was based on the Montana Constitution. So it's based on the state constitution of Montana, so there will be no appeal to the U.S. Supreme Court.
Really?
They could appeal to the U.S. Supreme Court and argue that parents have a fundamental right, to direct the upbringing of their children. There's some case law that supports that in a broader religious liberty context. But it's not likely. This was based on the Montana state constitution, and when a court issues a decision based on the state constitution, then it's unlikely that the U.S. Supreme Court will take the case unless there's a direct conflict with the U.S. Constitution. The Montana Supreme Court talked about, the restrictions that the legislation that the state of Montana imposed on, girls who would be seeking an abortion. And they said there's no corresponding limitation on a minor who seeks medical or surgical care otherwise related to her pregnancy or child. Just think about that for a moment. In the eyes of the Montana Supreme Court, getting an abortion and terminating a pregnancy is the equivalent of medical care for providing for the safe and healthy delivery of a child by a girl who is pregnant or even a woman who is pregnant. So to them, abortion really is just another form of health care.
But it isn't health care because a baby is being murdered every single time they perform one.
And, of course, it is a procedure that is designed to reverse the normal, healthy, functioning process of the body, the
right.
normal biological process of the body that is responding and showing that it's healthy. There's still some hope. Michael. Montana, at the same time, in 2013, passed another law called parental notification. So they were very smart when they did this. So in a sense, that's a backup. And that requires an abortion provider to provide notice to parents before a child gets an abortion. Now, those notification provisions can be pretty weak. They can, in practice, be useless if the notice occurs. If they put the notice in the mail, it waits a lot of time, and then the girl gets the abortion before the parents, get the notice, or for whatever reason it just happens to go to the wrong address. It doesn't work. There are a lot of problems with the notice provisions. So there's some hope there that would help mitigate this problem. But not surprisingly, the parental notification provision is also in litigation. And since the Montana Supreme Court has struck down the parental consent requirement, there's a fair chance they'll strike down the notification provision. They might not. What's really shocking about the decision is that the judicial bypass provision was there, which is required by the U.S. Supreme Court precedent. And Montana still just wrested away this decision from parents. It's just, as a parent, how important it is to be involved in critical decisions that children make when they're growing up. So, this is disappointing, but look, it's not surprising. Montana had a referendum back after the Dobbs decision was passed. Montana had a referendum called the Born Alive referendum. And it established, you might remember this, it established criminal penalties for doctors and healthcare providers who did not provide life-sustaining care to newborns who survived an abortion or who had other problems such as being born severely premature or who had fatal health conditions. And that went to a vote of the Montana people. Now, you would think that basic human decency would say that whatever the situation is, maybe the doctor was performing what they thought was a medically necessary abortion, which is legal and constitutional, and the church is not opposed to what would be considered a medically necessary abortion. People familiar with Catholic thinking are familiar, for example, with the principle of the double effect. It might be a situation where the child was born prematurely, where the abortion didn't have anything to do with it, but you have a live baby there. And you would think there would be just automatic that the people of Montana would say, well, yes, of course you have to provide health care for those people. And yes, if somebody just ignores the newborn infant, there's going to be a penalty. And Montanans voted down that law. They defeated that law in a referendum. After the Dobbs decision in 2022, there were at least 6 states that had abortion-related initiatives on the ballot across the country, and the pro-life side lost every single one of those. Every single one. They lost in places like Kansas. Kansas is not California. It's not New York. It's not Illinois. It's not even Montana. And they lost in Kansas. What happened was women especially and other advocates on that cause got motivated after the Dobbs decision. They came out, they registered to vote, and in Kansas, they voted against a pro-life provision there for a constitutional amendment that had actually been approved for before the Dobbs decision came down. So, Michael, this is just another reminder that pro-life forces have their work cut out for them. Those of us who are pro-life need to continue to fight. The Dobbs decision did not win the war. It simply moved the battlefield. It didn't really move the battlefield from Washington, D.C. and the Supreme Court and the federal government to the 50 states. It really expanded the battlefield because the battle still goes on there every time there's federal legislation. So there is, there's a lot of work out there. Hopefully, people will see this and the other pro-life measures that have been defeated in the last 2 years as a sign that we really still need to evangelize the culture. Because as you and I know, the ultimate answer to all of these social ills is evangelizing the culture. But there is good news out there, Michael. The Ninth Circuit, of all places, switching to a different issue on the religious liberty front, the Ninth Circuit recently handed down an interesting decision. In the state of Washington, there's a ministry, a homeless ministry, that was prohibited from hiring according to its Christian beliefs. They filed suit to protect their rights. The federal district court threw it out, and the Ninth Circuit, the most liberal circuit in the country, reversed the lower court and said, no, they have the right to go to court and argue for their First Amendment liberty. So we do win when we go to court and fight these cases. We don't always lose. That's actually quite amazing that would happen in the Ninth Circuit. Folks, we'll be right back with a bold synthesis of information and inspiration coming from a Catholic take. We'll be right back. A quick news break for you. Catholic Vote reports Harley-Davidson backs down on DEI. Harley-Davidson issued a statement backpedaling on its woke policies after a widespread backlash from customers. Conservative commentator and filmmaker Robbie Starbuck specified that the motorcycle giant recently released a statement in which they promised no more DEI functions, no more supplier of diversity spend goals. They'll no longer participate in the Human Rights Campaign scoring, and sponsorship activities are changing and will focus exclusively on motorcycling, first responders, active military and veterans, and no more woke trainings with socially motivated messaging inside them. LifeSite News reports British founder of LGBT Pride Group charged with over 30 counts of child sex crimes. Stephen Ireland, who is
a patron of Educate and Celebrate, the now defunct government-funded gender identity group allowed into thousands of schools across the UK, has been charged with multiple counts of sex abuse against children. The development raises alarm over how Educate and Celebrate were, for example, given access to nursery-age children across the country, while an Anglican chaplain was reported to counter-terrorism, sacked, and blacklisted as a safeguarding risk to children by the Church of England after raising concern about this group. And those are your headlines. And today we've got with us Bay Macfarlane. Since 2004, Bay Macfarlane has been upholding the dignity of marriage in light of no-fault divorce. With no-fault divorce, a party that still loves his or her spouse and wants to keep the family together is virtually defenseless. Mary's Advocates is a voice for faithful spouses and provides resources to equip those in positions of authority and influence to encourage reconciliation and denounce marital abandonment and unjust separations. Visit marysadvocates.org. Bay, it is good to have you on the program.
Michael, good to see you.
We've known each other for quite some time, I believe. I seem to remember meeting you back in, this would have been 2011 or 2012 when I was still working at American Life League. We met at one of Molly Smith's events out in Cleveland.
Yep. That's my diocese, Cleveland.
Very good. So why don't you tell us a little bit about Mary's Advocates and what you're up to?
Sure. Mary's Advocates' purpose is kind of twofold. One is to support those who are unjustly abandoned, support them morally, give them encouragement, provide resources just to keep one's equilibrium because it's a pretty tough road to walk. But then another mission is to reduce unilateral no-fault divorce. And what I found is a big roadblock to this is that, like, the moral authority of the Catholic Church is kind of dropped the ball on this one. So a lot of what I do is I spend my time showing parties who are unjustly abandoned how they can use the Catholic Code of Canon Law to try to uphold our own marriages. And people aren't aware there's a whole different process in Catholic. Go ahead.
I was just going to say, this is actually a very important. Go ahead.
Well, you finish.
Oh, okay. This is a very important point. The canon laws and the rules of the church always have sided on the integrity of marriage without establishing that, or even holding to the idea that, well, this marriage may not be valid, so therefore we're going to treat it as invalid until we get through the investigation and then get to a ruling, which seems to be the way things are run now. But traditionally, the church has always sided on the validity of the marriage, waiting for evidence or proof to show that the marriage was never existed, that it was nullified or should be nullified because it didn't exist before that. So the establishment of canon law and the way the canons work, my understanding, and correct me if I'm wrong, is also on the side of the marriage, but it's being used against spouses in the proceedings, the way that it's set up currently, the procedures. Why don't you walk us through that a little bit? Because I think that a lot of people don't really understand how this works.
Okay. And to help explain it, a distinction needs to be made between the practice and the actual law or doctrine and tradition or jurisprudence going back for centuries. Because the practice right now is if anyone feels that she's a disgruntled spouse and here's rumors about annulments are out there, and that person thinks, I'm bored of my husband, I want out, she could go to a priest and the priest could say, in perfect innocence, trusting the system, the priest could say, and I've heard people complain to me that this is what their experience was. My wife, I'm talking to the husband, the wife is told by a priest, well, you might have an invalid marriage. So you can have that checked out. It sounds like you might have an invalid marriage. And the kind of things the wife's complaining about are boredom. I don't like him anymore. I don't have that romantic feeling. He's a pain in the neck. We don't have the connection. I don't have the community of life and love. It's all this soft stuff. So that's the practice. But and then, well, how do I learn about an annulment, oh Father? And it's like, well, you got to get your divorce first. You get your civil divorce, and then the church will look at the validity of your marriage. So that woman walks out of talking to the priest, kind of feeling like, well, maybe the reason my marriage is no fun is because I'm actually not married. That's the practice. They require a civil divorce before they'll even look at the validity of the marriage, at least in the United States.
Yeah, let's stop right there, because when we look at the idea of divorce, Scripture is very clear. For the Lord hates divorce. That's a direct line from Scripture. And you start considering the idea of a divorce. A civil divorce has no merit or standing within a canonical court, or at least it shouldn't, because a civil divorce would be a civil declaration that has no bearing on the spiritual actuality of a situation. So the idea that a couple should be seeking a civil divorce before pursuing an annulment seems backwards.
Oh, it's way worse than that. And even what you said there is what we hear a lot. A couple pursues a divorce. Most divorces are unilateral divorces, one spouse against the other in a low conflict situation where there's not abuse and not adultery. So you've got one spouse pursuing the divorce, which you said earlier that there's no defense for the defendant. And then what the government courts do is they have no respect for the permanence of marriage. And they have no sense of the obligations of spouses to provide mutual help for maintaining one household. It's actually the opposite. So children are forced now, instead of having two parents working together to maintain one household. I mean, even if a mom and dad are annoyed with each other, there's a ton of benefits for stability and security and resources when you've got two adults in one household. But instead, the divorce splits it to two adults in two households. And then, people think, at least I used to think this until I started learning about no-fault divorce. I thought when you went to the civil court, you would get justice. And I had a notion from my Catholic upbringing, justice is where you give somebody their due. So the civil court's job is to give somebody their due. But in no-fault divorce, it's the opposite. So the husband who wants to keep his family together, who's done no adultery, no abuse, he's left facing the government taking away his children and taking away his property. And if the wife wants to live with those kids, she's going to be able to live with those kids almost always. It's what I see. So the husband's going to be paying for his kids to live in a house where he's not allowed to live. So and for the Catholic Church to require this is upside down, backwards.
Well, upside down, backwards, and wholly unjust, because what they're doing now is they are introducing a destabilizing scenario that will further degrade the marriage. So instead of allowing for any healing or even ordering, hey, look, you two need to treat this as if you're married and we need to work things out and we'll get to the bottom of it. They really, the introduction of the civil court to try and determine the efficacy or the solidity of a marriage prior to an annulment sounds not just backwards, not just upside down, but highly injurious. And assuming that the marriage, assuming that the marriage itself is valid and that there is a real valid, what happens then when the church says, you know what, go ahead and get your civil divorce and then we'll sort things out. Oh, but by the way, we've now looked into things. Your marriage is valid, which means you need to get remarried. Can you imagine the emotional roller coaster and the horror that would go on in a family, the fighting and the strife, if the church were to then reverse the ruling after the civil divorce?
And part of the reason why this is so wrong is that the church has competence over Catholic marriages. And people don't know, but tradition and the canon law says the church is the authority, the church principles are the ones that are supposed to be used to determine parties' obligations towards each other and their children. So if you've got this woman that's bored of her husband and she wants to go have her me time, according to church tradition and common sense, if you understand what marriage is, she's got no right to take the kids away from dad. I mean, if she wants to go sow her own wild oats, maybe she'll leave a lot. She won't be home a lot, but she won't have the power to destroy the household for the children and the other spouse. But in the civil forum, that's what she'll do. And the church, according to our own canon law, is the one that's supposed to be the determining the parties' obligations. Now, that's the practice. I want to switch over to what's actually the canon law. What is supposed to be happening? What's the way it's written in our canon law? And canon law is it's not just like some invented thing that a bunch of priests and bishops got together to, throw darts at walls and figure out what they felt like doing. It's based on salvation of souls. It's based on moral theology. It's based on church teaching. It's trying to put together a structure so that you can govern a society of the Catholic faithful towards the salvation of souls. That's what canon law is. Some parts of it are man-made, like, how many weeks before you have an option to apply or an option to appeal or something. But the canon law on marriage is all marriages are presumed valid until proven otherwise. And all spouses are obligated to live together in one household, supporting each other and their children, unless there's a grave violation that justifies separation of spouses. Then there's a difference between temporary separation and permanent separation. Adultery is the only grounds for permanent separation. And even then, the canon law encourages the aggrieved party to forgive. So, I say unrepentant adultery is the only reason for permanent separation of spouses. And even in all of those cases, you're still married. So, that's the basis that the church has. So to say that you have to go get a civil divorce before we even look at an annulment is very bad, is wrong. It's wrong. It's just wrong. Because the woman who's just disgruntled with her husband shouldn't even be separating from him unless he's an adulterer or dangerous.
Now, you've been in this particular field for a long time, and I'm sure you've argued this case with various canon lawyers, various priests, and even bishops and cardinals. I would be very interested to hear what kind of response you get.
Well, one I hear is that we require a civil divorce before an annulment because in the government there is a lawsuit that could be filed for alienation of affection. So if the church told you your marriage wasn't valid without your divorce, then the church could end up being sued for alienating affection from spouses. And that's ridiculous. That laws are only on the books like advice.
Why don't we complete that thought on the other side of the break here? We're coming on a break, and we will be back in just a few moments. So stand by, and we'll see you soon. Welcome back to A Catholic Take, a bold synthesis of information and inspiration. I am hosting today. This is Michael Hichborn, subbing in for Joe McLean as he is on a much-needed vacation. We're talking to Bay Macfarlane, who is the founder of Mary's Advocates, an organization that fights on behalf of disaffected spouses who are affected by no-fault divorce and unjust approaches to annulment and the problems of canon law or not just canon law, but procedure with regard to annulment as well. Bay, before the break, we were talking about the reaction that you get from priests and bishops and canon lawyers to the challenge that, hey, canon law says that you're supposed to follow a proper procedure, and you're completely dismissing what canon law is doing. You're dismissing the purpose of the canons with regard to marriage, and you're appealing for no-fault divorce prior to the pursuit of an annulment. So please explain to us, you started to talk about it. Why don't we go back and what kind of reaction are you getting?
One of the things that they also seem to not get, and I feel silly. I mean, I used to be a mom, right? And then I became this researcher, and I dedicated my life to finding out what the church really teaches about divorce and separation. The church teaches that there is supposed to be a canon law investigation before anyone was to ever approach the civil court for divorce or civil separation. Centuries ago, it was an absolute, almost an anathema to get a civil divorce at all. And you would never be allowed to get a civil divorce. And then it started to be, well, maybe in some circumstances it might be okay for you to get a civil divorce, but we got to make sure, we as the church, that you're not causing scandal and you have a good reason to be doing it. And some of the things that matter are whether there is a reason for separation of spouses at all. So yeah, maybe the abusive husband or the abandoning husband might have a wife who has a legitimate reason to need help from the government, if the government can help. And she'd still have to have her bishop's permission every time she goes to file for a civil divorce. That's the canon law that's on the books right now. And it's there to prevent scandal and keep marriages together and to offer pastoral care in the time of marriage crisis. So what I'm hearing instead is, and the way I hear this, the pushback, we have a petition on Mary's Advocate's website that's based in canon law, and an abandoned spouse can use it to ask the church to intervene. And it's got 2 pages of fine print showing the basis in canon law for this petition. And the petitioner is basically asking for an investigation in a case of separation of spouses, which is not an annulment at all. And the petitioner is asking the church, hey, can you help reconcile us? My husband or wife has abandoned me. And if he doesn't agree to work on reconciling, then I ask that you find that he's actually an abandoner. And there's a historical jurisprudence to support this. And what happens sometimes is a church comes back and says, okay, you want a decree of separation? Then go to the civil forum to get all the civil effects figured out. End of story. And the person is like, what? That's not what we were asking for. And there's this notion amongst diocesan personnel, I think. Well, actually, I know it's a notion amongst them. The ones that I dealt with and had to try to defend marriage against this notion is that the civil government handles all the civil effects of marriage. And then they go on to say the civil effects of marriage are property division, support, and custody of children and visitation time of children. And the canon law does use this word, civil effects of marriage. And it's used in context of when is a bishop allowed to give permission for a party to go to the civil forum to figure out a separation case. Because a separation case, including determining obligations, can be decided by your diocesan tribunal. This separation case for Catholics can also be decided by your bishop. And in some circumstances, a separation case could be determined by the civil forum. But that's only supposed to happen if you have permission from your bishop first, and the civil forum will create an order that's not contrary to divine law. So, and the bishop, and this is where the civil effects words come in. Let me bring myself back to make sense out of this. The bishop could give permission for the civil forum to handle the merely civil effects if all those other conditions were met. But then you start to ask, well, what is merely civil effects? Because this is like philosophical stuff, so I'm a little bit weak on it, but the things I make that are clear is there's some kinds of effects of marriage that are purely spiritual.
Sure.
Okay, maybe there's some kinds of civil effects that are purely civil. Then there's some kind of effects, did I say that wrong? There's some effects of marriage that are purely spiritual, some that are purely civil, and there's some that are mixed. So the ones that are mixed, you're not allowed to give to the civil forum. You're only allowed to give to the civil forum the ones that are merely civil effects. An example I come up with is your tax status. gee, do I file my taxes as a married person or as a single person? That doesn't have too much to do with the moral obligations of spouses towards each other and their children.
Right,
but
right.
The obligation.
One of the things that I'm kind of hanging up on here, and I'm listening to you, and I'm listening to what the bishops and the priests are attempting to do, but they've stacked the deck so much against the marriage by handing over all of this authority over to the civil government first, saying, okay, pursue your civil divorce first, which usually requires a legal separation for a period of time, at least in the state of Virginia. You have to be legally separated for a year before you can pursue a civil divorce. So even there, the church is ceding authority to the state and saying, well, the legal separation isn't up to us. It's going to be up to the state to determine. So the state's going to set up the separation, and then the state's going to determine whether your marriage is going to be invalidated. And then we'll conduct an investigation to figure out whether it was actually a marriage or not. And that's when so they're stepping themselves out of the entire process up until the end. And then at the end, it sounds like what they're doing is they're simply affirming what the state finds. Can you imagine if priests and bishops ceded the validity of their orders over to the government first? And the government says, you know what, Bishop, we don't know if your consecration as a bishop is valid, so we're going to divorce you from your church, and we're going to go through a process to determine whether you should actually be a bishop here in the state of Virginia or not. And then the church can have a canonical process to figure out whether your holy orders are valid or not. Can you imagine?
Right. And in the meantime, you have to go work at Walmart or wherever you can get a job, teach in a high school or something, because you don't know if you have your job or not. It's
right.
And because the practice is so contrary to the actual church moral theology and canon law on marriage, Mary's Advocates right now has a petition, and you signed the petition, thank you for that, where we're asking everyone to join, because I'm going to send letters to all the archbishops in the United States about this problem, asking the archbishops to stop this divorce mandate before they look at the sacramental nature of a marriage.
Right. I don't even understand how they can justify turning to the state first. It's such a like they're ceding so much authority over to the state. It's just insanity.
And the scandal
I'm going to give you the last word. Go ahead.
The scandal it's causing, because everyone sees people getting divorced who are supposedly good Catholics, and there's no response from the church at all. We're just treated like everybody else. I mean, if I was an abortion doctor or I was forcing transgender surgeries on people, you would hope the church would say, hey, that person can't be doing what she's doing and call herself a good Catholic. But you can abandon your spouse, and the church is totally silent. And it's supposed to be our teacher and our shepherd. And it's not helping the souls of the abandoners either.
Faye, thanks so much for joining us. Thanks so much for joining us at A Catholic Take. I am Michael Hichborn. I've been with you for the last 45 minutes, actually. Download the iCatholic Radio app for the podcast. Go to the landing page at